What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace because when she comes back in here, it is going to be a...
This case starts in chaos, and that chaos matters. Right out of the gate, you can feel Judge Simpson trying to regain control of the courtroom, calling people back, demanding order, and immediately signaling that something is off. This isn't just noise, this is the court setting the tone. When a judge has to repeatedly stop proceedings to bring someone back into the room, it signals procedural confusion and possible credibility issues. And credibility, in landlord-tenant cases especially, is everything. What's critical here is that the judge doesn't jump to emotion, he jumps to jurisdiction. That's a legal word that sounds boring, but it's deadly serious. If a court doesn't have subject matter jurisdiction, nothing else matters. Not the story, not the frustration, not who you feel sorry for. The judge is essentially saying, before we argue fairness, I need to know if I even have the legal power to hear this case. This is where many self-represented litigants get tripped up. They believe filing paperwork is enough. But courts don't run on intention, they run on precision. Dates, service, proof, and compliance are not suggestions, they are requirements. And when those requirements aren't met, the court doesn't get to fix it for you. So as this case unfolds, keep this question in mind. Is this a misunderstanding? Or is this something much more serious? Because Judge Simpson is already hinting that the problem here isn't small. It may be fatal to the entire case.
State your names.
Carla Green.
Antoinette.
Dustin.
All right, where are we on this, folks? Because,
I filed the proper paperwork.
well, I don't know that you did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. When we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it. And I adjourned it out to give you an opportunity to correct that. Because if it had been served, it was. So you filed with the court a notice to quit. And importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. And that you served it on them March, as I'm looking at it here, March 10th, 2025.
This is the moment where the case quietly collapses, even if the person arguing doesn't realize it yet. Judge Simpson is walking through the timeline slowly, deliberately, almost like a math problem. And that's because eviction law is timeline-driven. A notice to quit isn't about emotion or urgency, it's about legally valid notice. Here's the core issue in plain language. You cannot tell someone they must move out by February 28th if you didn't even notify them until March 10th. That's not a technical mistake. That's a legal impossibility. The law requires notice before the deadline, not after it. Otherwise, the tenant is being punished retroactively, which courts will never allow. This is why judges obsess over proof of service. It's not about trusting someone's word. It's about protecting due process. Without proof that the tenant was properly notified, the court assumes the tenant's rights were violated, even if the landlord believes they did. Everything right. Audience question. If you were the judge here, would you keep listening, or would you already know the case is over? Because Judge Simpson does, and he's about to say it out loud.
Is what it looks like to me. And it says it's served by first-class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be true. Because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. the only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid.
When a judge uses the word invalid, that's not a warning, that's a conclusion. Judge Simpson isn't debating anymore, he's diagnosing the problem. The notice to quit fails on its face, meaning even if everything else were perfect, this document alone kills jurisdiction. And notice how he explains the logic instead of just asserting authority. That's important. Judges do this for the record. He's building an appellate-proof explanation. He's saying, if anyone reviews this later, here's why this could never work. The dates don't just conflict, they contradict reality. And when legal documents contradict reality, courts don't bend, they dismiss. This also explains why the judge keeps referencing subject matter jurisdiction. Without a valid notice, the court legally cannot proceed. It's not a choice, it's not discretion, it's mandatory dismissal. This is also where things get tense, because once a judge starts questioning whether documents can't be true, the conversation shifts from mistake to potential misconduct. Ask yourself at this point, would you still be arguing, or would you stop and reassess?
With the dates that are on here, it can't be true.
I additionally went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of me serving them the correct way. So the first time I served them was
January. And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking at it, have a problem with, that they would have received a summons and complaint from the court. They would have had an officer or somebody show up to serve that. That I'm not having the issue with, and that's what I was trying to explain at the last year. Because the document you handed me, that you were talking about that. What I told you was the notice to quit. I didn't have a copy of when it was served on that. Gave you the opportunity, you said you did, I gave you the opportunity to correct it. I'm not sure what date it was received, but the document that we received that was received by the court is a notice to quit to recover possession of the property. I will say two things about that. First of all, it doesn't match. The top portion of that notice to quit does not match what I have in the file, which leads me to believe that it's not the document that was served on them, if it was served. Then even aside from all of that, and so in reality, it's not a valid notice to quit. But even aside from all of that, if I were to say, give me the benefit of the doubt, I'll just look at it, I'll take the dates. You can't give somebody a 30-day notice.
Judge Simpson is now doing something very deliberate. He's teaching the law on the record. He gives a hypothetical. If I serve someone today, here's when they move. This isn't for the litigant alone, it's for anyone watching. The judge is stripping away excuses and replacing them with clarity. And notice the frustration creeping in. Not anger, frustration, because the court already gave an opportunity to fix this. An adjournment was granted specifically to correct service defects. That's not automatic. Judges don't like wasting court time. When they give you a second chance, it's usually the last one. This is where credibility starts to erode. Multiple versions of the same notice. Typed versus handwritten. Different dates, different claims. From the court's perspective, this isn't confusion anymore. It's inconsistency. Engagement question: do you think this was a paperwork mistake or something worse? Because the judge is clearly leaning toward a very uncomfortable conclusion.
Tell them to move by February 28th and not tell them until March 10th.
Your Honor, I think it's a misunderstanding. I served them a notice to quit on February 28th because I'm following all the court steps. She said, first of all, you have to file a notice to quit yourself. And then if they don't move, you come to court, you file this paperwork, and then you come to court. So I served them, correct?
No, you don't get the question. What are you saying? You have to give me a proper service here. And I don't have it. I don't know what that notice to quit. You keep saying that you gave them one. I don't know what it says. Because your two notices to quit are different. The one that you gave me just recently is different than what was attached. The top portion is different than what was attached to the complaint that was filed. One is typed, the other is handwritten. It says moved by the 28th, but the way it works on a 30-day, I tell you, if I were to give somebody right now a 30-day notice today, the 18th, I would say if I serve it on somebody today,
Your Honor, I served it on January.
just don't interrupt me. April 18th, I would give them until May 18th to move.
Correct.
Your notice, on the other hand, says you have to move by February 28th, but I don't tell you that until March 10th.
That's the second.
Can't work that way.
That's the second notice, Your Honor. The first notice, they told me to serve it. You have to have a 30-day notice to quit. I served them the 30-day notice to quit January the 28th. So they had till February the 28th to move.
Then why don't I have a proof of service that it was given to them on January 28th? I don't have that. I told you to come back, and usually I wouldn't do it. Usually I would have kicked this case the last time. You kept telling me that you had it. I see a notice. I don't have the proof of service on the notice to quit. I gave you an opportunity to correct. What I got,
Your Honor,
is an impossibility.
Your Honor, what you got is what the court told me to do. They said file a 30-day.
You're not going to blame the court. The court didn't tell you to do this, because I think this is a falsified document if you want to really get down to it. Because the notice to quit that I have in the file is typed. The notice to quit that you gave me is handwritten. It can't be the same. I don't want to accuse you of providing false documents to the court, but that's certainly what it looks like.
This is one of the most dangerous moments any litigant can face. Judge Simpson doesn't outright accuse, but he comes right up to the line. When a judge says, I don't want to accuse you of providing false documents, but, that but carries enormous weight. Accusing someone of falsifying court documents isn't small. It can lead to sanctions, contempt, even criminal referrals. And the judge makes it clear, smiling, dismissiveness, or deflection will not help. The court takes integrity seriously. What makes this moment powerful is that the judge isn't emotional. He's controlled. That control signals confidence. He knows what the record shows, and he's giving a final warning. Audience question: if you were standing there, hearing this from a judge, would you still argue, or would you realize the damage is already done? Because from the court's perspective, trust has just been broken.
And secondly, the date, as I indicated, and I will say, you can smile at me all you want, but I'm going to tell you right now, if I think you filed a false document, you're going to get a show cause, and you're not going to like what happens. Am I clear?
Yes, sir.
The document that you gave me is a factual impossibility. You cannot tell somebody to move February 28th and serve them on March 10th. It can't happen that way, because you're telling them to move after the time that you told them to move. You can't do it. That's what's in this file. So giving you an opportunity to do that, I've given you an opportunity to correct it. You failed to correct it. I will state on the record, I think you provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction.
And just like that, the case is over. No eviction, no ruling on the merits, no weighing of fairness, a full dismissal. This is the cleanest and most unforgiving outcome in civil court. Dismissal for lack of subject matter jurisdiction means the court never had authority to hear the case in the first place. Everything that happened before becomes legally irrelevant, and if this case is refiled, it must start from scratch. With proper notice, proper service, and proper documentation. But notice what happens immediately after. Chaos returns, someone leaves, the judge calls them back, tension spikes again. Because even when a case ends legally, emotions don't stop instantly. This moment sets up the second half of the video, and it's a dramatic shift. We move from procedural failure straight into a deeply human crisis involving honesty, addiction, and life or death consequences. And that contrast, cold law versus raw reality, is what makes this courtroom unforgettable.
What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace because when she comes back in here, it is gonna be State your name.
April Joy Fleming.
Yeah, I'm asking for hopefully one last adjournment. We've been adjourning for medical records. We did get some medical records, are waiting for records from Trinity Health. Hopefully I can get that mitigation over to the people and come to it.
Ms. Fleming,
Yes,
were you huffing on Zoom?
I'm sorry.
Were you huffing?
No, I was not.
Are you sure?
Yes,
So if it was reported to me by two people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Today? No.
Where do you live?
I live at Chittister Place Apartments.
How long will it take you to get here?
I don't have a ride or anything. I don't know. To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like on camera? No.
Okay, today off camera, on camera, you been huffing?
No.
Not at all?
No.
So if you came down here and I sent you over for a test, everything's gonna come back negative?
Yes.
It will?
Yeah.
Okay, you're gonna need to find a ride. I'm gonna need you down here.
Okay, sir. I don't know how I could get there.
Ms. Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
Fleming, say your name for the record, please.
April Fleming.
All right. Well, thank you for coming down. Miss Fleming, I'm gonna ask you again.
I did. I was.
You did what?
I huffed.
This confession changes everything. The moment April Fleming admits she was huffing, the courtroom dynamic locks into a life or death framework. Judge Simpson isn't reacting with anger, he's reacting with urgency. Huffing compressed air is not casual drug use, it's medically catastrophic. One use can kill, and the judge knows this. What's especially important is the judge's focus on frequency and intent. He isn't asking to shame her, he's assessing risk. Courts have a legal obligation not to release someone if doing so creates a foreseeable danger to their life. That's not punishment, that's protection. And notice the judge's language. You're going to end up dying. That's not hyperbole. That's a warning grounded in medical reality. Audience question, should a judge prioritize compassion or intervention, even when the defendant begs for freedom? Because sometimes the most compassionate decision looks like the harshest one.
You were huffing. Yeah.
I'm sorry. I made a mistake.
Why weren't you? Why were you lying to me when,
I panicked. I just panicked. And I'm so sorry. I'm really, really sorry.
ma'am, how frequently are you doing this?
Um,
I mean, are you doing that every day?
sometimes.
I mean, you're gonna end up dying from that.
Can you give me
I
another
mean,
chance today, please?
Is that what you're trying to do? Are
No,
you trying to kill yourself?
no, I'm sorry. I just,
Okay, so, but how long have you been doing this?
about, I don't know. I've tried it off and on for a year or so.
Have you thought that you might need to get into some type of treatment or something? Have you,
I need to,
but you haven't done that.
I guess I haven't had anything like this happen. Uh, I plan on getting in touch with,
Who are you gonna get into? You don't even know.
huh?
You don't even know who you're gonna get in touch with.
Well, I know I have to speak to,
Well, I will say Miss Fleming does go to therapy at, Huron Valley Consultants.
yeah,
As I've stated, we've been working on getting those medical records. I have reviewed some of those medical records. It indicates they do talk, and Ms. Fleming's on methadone. We're still in the methadone program. So I do know, I will say that there are entries that they've had these types of conversations about her past use. So I think it's something that Ms. Fleming knows that she
I
deals with.
Yeah.
Have you told them that you're huffing?
No,
You
I-
haven't.
I know I have to. I
Sure.
plan on speaking to my counselor today.
When's the next time you see your therapist?
I can see him tomorrow morning.
Okay, so Miss Fleming, here's what you gotta understand. For me, when you tell me that you have an appointment, when you tell me all these things, it becomes hard for me to believe whether or not you're telling me the truth.
I understand that.
And that's because I asked you a series of times when you were on Zoom.
I freaked out. I should have said the exact truth, and I'm so sorry, Judge Simpson. Please give me a chance today, please.
Well, Miss Feltus, you want to say something?
I do, Your Honor. Ms. APA Cook was able to review the YouTube footage, and we shared with Ms. Kearney a screenshot that did show the defendant with the canister in her hand. I recognize that canister to be what I commonly refer to as dust off or computer cleaner, a type of compressed air. I'm very familiar with this drug, and I know that any time that you use it, it can cause instant death. This is a drug that is extremely dangerous, and the way that this is being ingested can lead to long-term issues as well as immediate death. The brain can die every time you do this.
This prosecutor statement is one of the most sobering moments in the hearing. It reframes the case entirely. This is no longer about bond compliance. It's about survival. The mention of computer cleaner, commonly used for huffing, isn't speculation. It's based on visual evidence reviewed from recorded footage. What stands out here is the prosecutor's tone. This isn't adversarial. This is protective. She's explicitly asking the court to act not out of punishment, but concern. That matters. Judges listen closely when both sides align on risk. The law allows bond modification when circumstances change. And this is a drastic change. A defendant actively engaging in lethal behavior triggers the court's duty to intervene. Engagement question. If the system lets her walk out and something happens, who bears responsibility? Judge Simpson is already answering that question, and he's not willing to accept that burden.
I think it's clear the defendant's very scared. I think it's clear that she wants to change. She wants to stop using. I really want to see her again, Your Honor. I'm very worried that we're not going to see her again. I truly, truly want the court to hear that this coming in from a place of compassion and concern, not a place of bond violation. Is coming from a place for the people of actual concern. We will not see her. I am requesting that the court consider bond change with a release to treatment for her to get some help. But I do know that my experience with this drug and all the education I have surrounding drugs in general leads me to believe this is an extremely risky behavior. I ask the court to consider a bond change.
Please, Your Honor, please.
I do know Miss Fleming does have a medical team around her. She sees her primary care doctor consistently. As I stated, she is in therapy. I think everyone's concern for Miss Fleming is warranted, especially the circumstances that this arose out of. I'm happy to work with her and get information to the people in the court if the court allows her to stay out of custody. Obviously, if she's in custody, that will take place too. I'm just asking that the court consider letting us work on that while she's out of custody.
Please.
She does have some medical issues that, and that's partially why she sees her doctor so consistently. This is an old retail fraud. I do, it's this case, I don't believe has anything to do with her use or anything like that. I just asked for a chance.
Might, because if she's been using for off and on, as she's indicated, a year, this offense is in June of this year.
Well, I mean, I don't know exactly how long I've been using it. It's been for some months now. I don't know if it's been a year exactly.
Okay, Ms. Fleming, here's how I know you're an addict. You tell me one thing, and then when all of a sudden that doesn't seem like that goes your way, you change your story.
This is the credibility collapse. Judge Simpson articulates something courts see often in addiction cases: shifting narratives under pressure. He's not diagnosing, he's observing patterns. And those patterns matter because release decisions rely heavily on trust. The judge acknowledges compassion, but he also acknowledges reality. Promises made under fear don't override documented behavior. And once a judge believes they've been lied to repeatedly in the same hearing, the legal margin for release disappears. This isn't about punishment. This is about risk management. The judge cannot rely on assurances when the evidence contradicts them. Audience question: do you believe people deserve endless chances or structured intervention when self-control fails? Because the law doesn't allow judges to gamble with someone's life, even when they beg.
You did that in rather rapid shot fashion when you were on Zoom.
I'm so sorry.
No, Miss Fleming, sometimes things happen for a reason, and not all of them we like what happens, but they happen for a reason. And maybe it also goes to what Ms. Feltes said.
Please keep me out of custody today. Please, Judge Simpson, please. I'm begging you.
You can't stop.
I am stopping. I'm done. I promise. I
And
promise
here's
with
my
everything
problem,
in
Miss
me.
Miss Fleming, here's my problem. You've already lied to me today, repeatedly.
I am so sorry. I am so sorry. I got here as soon as you said, please to come down. I got right on the bus and I came
It
here.
was either going to be, and I think you understood, if you didn't come down, we were going to come and get you because there was going to be a bench warrant.
Okay. I think you're scaring me straight.
No, I don't think I have. Certainly not yet. But I'm going to let you know, if you think for 1 minute that I'm going to sit here when I know what I know at this point and have you die on my watch, and I haven't used what tools I have to try to make sure that you stay alive, you're sadly mistaken.
Please don't take me in today, Judge Simpson. Please, I'm begging you, please, please, everything in me, please. Please give me one more chance, please. Please, Judge Simpson.
And I will add, Your Honor, Ms. Fleming was honest with me when I spoke with her. I think she understands the reality of the situation.
Anything else you want to tell me?
Just that I'm going to tell you the truth from here on out. I swear on everything in me. I swear on everything in me, Judge Simpson. I swear on everything in me. And I voted for you.
Doing about the 65 other thousand, but thank you, Agnes. You're not dying on my watch, not tonight.
I'm not going to die
I'm
tonight,
done.
please.
I'm done listening. Listen to me now.
Okay.
You're not going to die on my watch. I can't trust you. I don't know what therapeutic routine you have, what you have surrounding you that I can safely let you out. Because whatever you're doing at this point, you do it, you go home and you're huffing.
I won't,
Yeah, I know, you're gonna tell me I won't do it. You're gonna tell me that all that
please, Judge
stuff.
Simpson, please.
Miss Fleming, I've heard it all before. And then the next thing I know, before we even get you your case again, guess what? I'm online reading about your obituary and I'm not doing it. I'm just not doing it.
This is Judge Simpson's breaking point, and it's grounded in responsibility, not emotion. When he says, "I'm not reading your obituary," he's drawing a firm line. Judges are sworn to protect life when they have authority to do so. And here, that authority is bond control. He explicitly states the fear: release equals risk of death. And when risk outweighs trust, custody becomes the only legally defensible option. This is the court saying, "I would rather you be angry and alive than free and dead." It's also important that he leaves a door open. Conditional reconsideration if verified treatment information comes in. That's not cruelty. That's structured accountability. This is intervention, not abandonment.
If they can get the information, I'll take a look at it and I'll potentially reconsider. I'll set a review of her bond on December 22nd, 2005 at 9 o'clock. But at this time, her bond is revoked, defendant's remanded.
I'm arrested? Oh my God.
This hearing ends with two stark outcomes. One case dismissed because procedure failed, and one person remanded because survival was at stake. Judge Simpson's rulings show both sides of judicial responsibility: strict adherence to law and uncompromising protection of human life. The eviction case fell apart because legal rules weren't followed. The bond was revoked because honesty broke down and danger escalated. In both situations, the court acted consistently, transparently, and on the record. The broader lesson here is uncomfortable but critical. Courts cannot fix broken process, and they cannot ignore lethal risk. Paperwork matters, truth matters, timing matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.